So if you don't know, there's this guy named Assburger. He's an associate of Mumkey Jones, and he is friends with this guy named Brandon, and Brandon's girlfriend Jackie. And I'll probably pull up his video in a little bit, and we'll talk about it because it's important to kind of see what this kind of stuff does. But apparently Brandon is an alcoholic. Anyway, this guy was a alcoholic, apparently had alcohol problems, and during what is called a relapse, he viciously, allegedly, I don't think there's much alleged about it, attacked his girlfriend, who goes by the name of Jackie. I know nothing about him or Jackie, but he attacked her. He allegedly strangled her. He allegedly bit her very hard on her leg. Probably left a mark, maybe some bleeding, I don't know. But very serious attacks. Bites are very serious attacks. But so what he is charged with, aggravated assault by strangulation, that's a felony. Because when you strangle someone, you're typically, like the associations, that you're attempting to kill them. And it puts them in fear of their life. They fear that they will be killed in that moment if they cannot get away. So that's, don't want that. That's a felony charge in Georgia. Battery, misdemeanor battery. That is probably related to just the overall hitting and the bite and stuff like that. Any battery, misdemeanor battery is probably stuff that leaves marks and is a risk of bodily injury or causes bodily injury, but not serious or severe bodily injury. Misdemeanor battery is probably just surface level bruises, cuts and scrapes, or minor bleeding, but no permanent damage being done. Sexual battery, I think we can assume what that has to do with some sort of sexual assault maybe occurring. And then finally, obstructing or hindering persons making an emergency telephone call. So if you are in the process of beating someone and they attempt to call 911, you cannot stop them from calling 911 or you get another crime. So if you're in the process of beating someone, I want to stress this out, and the person picks up the phone, it's very important that you stop beating on them and let them make that phone call. Sexual battery is maybe from the bite to the thigh. Possibly. That is a possibility. I don't know. And here's the problem. I did all kinds of internet sleuthing. I actually did find Brandon's first and last name, the county he was arrested in, and by me, like, I didn't find it. I went to a website where someone else had found it and posted it, and then I used that to attempt to get to the court documents. Now, the court documents are not available yet. In some states, court documents are not available until after a conviction occurs. In some instances, when you've got a domestic assault victim, they have a level of privacy that makes the documents unavailable. I will continue looking for these documents, but they're not currently available in the county under the case number that exists. It could just be that they've arrested him in the immediate situation, have not filed the formal charges yet. I don't know. But that's the charges he faces. All right. Mumkey called the police. Mumkey and his girlfriend apparently called the police. And that's the right thing to do. Honestly, my understanding is that Jackie no longer wants the charges pressed against the guy, against Brandon. Okay. One, the state doesn't need your permission to press charges, especially felony charges, felony assault. They don't need the permission of the victim. What they may need, depending on the circumstances, is they may need statements from the victim that the victim is unwilling to provide at a later date. That's a thing. I have done cases that involve this. I have had a couple cases. One, for example, I had a case where a guy and his wife got in a fight. She threw something at him. He struck her back, actually caused a broken bone. because he's a man and she's a woman, and that's misogynist, but that's fine. He, struck her back in sort of reaction or retaliation. He was charged with a crime. She didn't, she called the cops on him after talking to a counselor, like the next day, called the cops to report what happened. Cops charge him with a crime, and then she doesn't want that crime later. State says, too bad. Not your thing anymore. So then the state has to run their case, though, on the testimony or any sworn statements that she's made or statements that they've recorded that she's made to the police, and any statements that he makes to the police. That's where they're, and any other witnesses that may be involved. If she doesn't want to cooperate further, like she doesn't want to provide her medical records, like they could try and go after him, they can threaten her, but she's not a party to the suit. She's not a party to the suit, so the state will have trouble getting those without her consent. And if she doesn't want to testify, even if they do get them, like, oh, we got your medical records. Well, introducing them as evidence is going to be tough because you get a document, you can't just introduce it as evidence. You have to lay foundation for the document. Do you recognize this document? Yes. Well, what is it? Well, it's my medical records. Well, what's it say? Oh, it says I got a broken arm or whatever on this date. Okay, we'd like to enter that, into evidence. You got to lay foundation. You can't just say, here's some medical records for this person. The other attorney would object, right? Like you got to lay that out. If you have an uncooperative victim and that's the only witness, that can be real tough for a prosecutor. Well, too bad. Too bad for prosecutors. No one's crying for you. You're all at some level terrible people. Even the ones I like. I'm sorry. But no, I'm just kidding. Just kidding. But that's part of the gig, right? Like the state has the hard job in criminal cases. Is supposed to. They actually don't, but they're supposed to. So if the victim refuses to cooperate, you've just got the initial statements from the victim and that's it. So if the victim didn't tell you anything other than like, he hit me, well, that doesn't really help you create a battery case unless you've got some other supporting evidence. So if Jackie says, I don't want to cooperate, well, a whole lot of that's going to depend on what Jackie's already told the police, what anyone else who has talked to them has already told the police, what statements they think they can include and not include will really depend. And of course, what Brandon has said to the police is going to really matter too. So who knows what's out there, but if you don't want them to charge someone, you can't even call them. And that's a bad plan. It's a bad plan. And here's the thing. And then I had another instance where, sorry, to backtrack, I forgot I wanted to give the other side of the story. I had another instance where a guy was charged with hitting his long-term girlfriend, and from day one, she swore that he didn't ever hit her at all. And then, she wrote letters and stuff. And the state still wanted to press charges because they thought that maybe they could force her into giving a statement. So it kind of goes both ways, but you may not want charges pressed, but if they have probable cause, and that's kind of a low bar, then they'll go after it. The state can go after it. Okay. So here's how these cases go. The next steps will be how much Jackie wants to cooperate with police. It'll heavily involve statements made by Jackie and Brandon to the police. Those will be the most impactful statements. They're the people who were there. Next will probably be any statements that Mumke and Sheepover made to the police, if they were questioned at all. I have no idea. Those will be less impactful, probably used to verify statements made by Jackie. This is a tough situation. If they can back any of this up, even if Jackie doesn't want to testify in court, if they've got recorded statements from her, and a lot of times a cop will interview someone with a body cam on, they'll wear a body cam while they do the interview with a victim. to make sure that they've got those recorded statements that they can accurately write down and not play the recording of, but they can write down and read later in court. They'll do that. If they've got any recorded statements from her, they'll be stockpiling those in the case that she wants to say no to helping out with the prosecution. We're not going to get into that. So let's see. So this is a felony charge. I don't know what the actual... Let's look up the statute, right? Let's just go ahead and... What do we got? OCGA 16.521B. A person convicted of the offense of aggravated assault shall be punished by imprisonment for not less than 1 year, nor more than 20 years. So up to 20 years. The specific citation... a person commits the offense of aggravated assault when he or she assaults... and this is subsection A3, with any object, device, or instrument which, when used offensively against a person, is likely or actually does result in strangulation. So there you go. Strangulation. So when they say strangulation, they mean with any object, device, or instrument. So there is probably like a cord of some sort used to aid in the strangulation, or maybe like a bar, something that they could push against the neck. It doesn't necessarily mean hands were used to aid in the strangulation. But that's the allegation on the strangulation. It's 1 to 20 years in prison on that count. What I would think is a potential outcome. I don't know Brandon's criminal history. I don't know his criminal history, so I can't tell you. So if I'm representing a guy like Brandon and we're looking at a plea deal, this is completely different. This is speculative. Let's take the assumption that what is stated as true, that he was hitting her, he was strangling her with some sort of object. Okay, so yeah, it looks like the bite on her leg, if that took place on her inner thigh, then or groin area in any way, that would constitute the sexual battery. Or even if he just grabbed her inner thigh, like if he, in the course of the fight, grabbed or like struck or pinched or something, her inner thigh while struggling with her, or if he was grabbing at her genitalia or breasts or something like that, which of course would also be possible if they were tangled up in fighting, that would be a sexual battery. It's an aggravated misdemeanor, which means less than a year in prison, but up to a year, or in county jail, up to a year would be the convictable offense. Probably a fine of up to $1,000. I'm not familiar with Georgia's code, but that's what I'm guessing. So anyway, sorry about that. All of that considered. So let's say, yeah, he's hitting her. He's attempts to strangle her with some sort of object. He bites or grabs her inner thigh, causing bruising that they can prove. So that's a sexual battery. And then he prevents the phone call. My guess is he pleads guilty to either a felony battery of some sort, felony domestic assault. Maybe they drop the sexual battery. They probably drop the misdemeanors. They have him plead guilty to the felony, and they have him serve like a minimum sentence with part of it stayed on the condition, since alcohol is involved, I'm guessing the condition of counseling, a condition of probation, significant probation, 3 to 5 years, probably. Again, just guessing, not knowing that Georgia's guidelines, but this is the type of stuff you'd look for on this. Now, what you'd really want them to do, even though it doesn't really matter in the scheme of things, is to drop that felony to a gross misdemeanor or a misdemeanor assault. And that would be on the cooperation of Jackie, right? Like if Jackie doesn't want him to go to prison, what she could do is say that she won't, she's not going to testify. And then they might not have as strong of a case to lay all these charges on the table. They may be willing to negotiate or bargain. If you can get that felony charge down to a misdemeanor charge, plead guilty to the misdemeanor charge, you can probably get a very limited amount of jail time, maybe a couple weeks, maybe less, honestly. If it was a woman, you'd get her out of jail real easy. I'm not even joking. But if it's a guy, you get him down to a minimal amount of jail time, a long probation term, 2 to 3 years for a misdemeanor would be a long probation term, and a lot of counseling. You got counseling. You've got Alcoholics Anonymous or some other treatment program for their alcoholism, and they would have to, as part of their probation, complete the treatment program, have regular updates with their probation officer from their sponsor and treatment program person to provide their progress on treatment. These things are things that you could realistically expect on a first offense. I don't know if this is his first offense, but if it is, you could honestly expect a plea deal that has a couple weeks in jail, and that would be, I mean, a month in jail would be a long time if it's a first offense, and they don't have a cooperative witness. Now, if Jackie wants to go for it, if Jackie wants the state to push into it, she makes a really harsh victim impact statement, and is willing to testify, you know, they won't drop that to a misdemeanor. But if she's not cooperative, they might be willing to drop it to a misdemeanor. He'd serve a couple weeks in jail. I don't know how Georgia does it. In Minnesota, you could actually stagger it out. So let's say you get sentenced to 14 days in jail. Well, that's like 7 weekends over a 60-day period, or even a 120-day period, depending on the judge. So you go in for 7 weekends, so you can still keep your job and stuff like that. That might be a possibility, in all honesty. And if that's the case, plus a fine, right? And I'm guessing the fine, if they got it down to a misdemeanor, a fine of $750 to $1,000. But they're going to drop all the other charges. The 911 obstruction charge, you know, if he's doing a plea deal, that thing's gone immediately. I think they would get the battery charges. They'd just pick the felony one, have him plead to that. If Jackie's kind of maybe going to testify but not giving them good answers, or if they have some problem with their case, I don't think they're going to have a problem with the case, but you know, they could get him to plead to the felony. If I was representing him, I would look for, if he's pleading to the felony, the sentencing guideline is 1 to 20 years in jail or in prison. So I would request the 1, and we'd ask for like a stay of adjudication. I don't know if Georgia does that in the same way that Minnesota does, but in Minnesota, you could get a 1-year sentence and you could get the majority of it stayed. So assuming they don't reoffend during their probation, the charges actually fall off and they don't have to serve the whole thing. So that's the type of stuff you'd be looking for on a plea deal. That's assuming everything is relayed accurately to what happened. Watched Mumkey's video. Kind of sounds like that's what happened. And Mumkey had the opportunity to put Jackie in a trash can and say that she was lying or whatever. I don't, you know, he could do that if he was mad at her for how he perceives he was being treated by her, which if I take him at face value, what she did to him was also wrong. Very, very wrong. But, you know, if he had decided to take that out on her and say that she lied, that would complicate things. But it doesn't seem like he's doing that. So I'm going to take it at face value that that's probably what's gone on. That's kind of an idea of what you'd be looking at on plea agreements on this stuff. So don't be too surprised if they do resolve this by plea, if he's actually out, if he's out of jail, maybe doesn't even have to go at a specific time, might have just a window of time to complete some days, and you may never even know it. Of course, other than being able to watch the documents, or if anybody leaks the information, of course, then we'd know it. But until that happens, we won't know.